Procedural law or adjective law comprises the rules by which a court hears and determines what happens in civil lawsuit, criminal or administrative proceedings. The rules are designed to ensure a fair and consistent application of due process or fundamental justice to all cases that come before a court. Substantive law, which refers to the actual claims and defenses whose validity is tested through the procedures of procedural law, is different from procedural law. In context of procedural law, procedural rights may also refer not exhaustively to rights to information, rights to justice, rights to participation, which those rights encompassing, general civil and political rights. In environmental law, these procedural rights have been reflected within the UNECE Convention on Access to Information, Public Participation in Decision-Making and Access to Justice in Environmental Matters, known as the Aarhus Convention. Legal procedure. Although different legal processes aim to resolve many kinds of legal disputes, the legal procedures share some common features. All legal procedure, for example, is concerned with due process. Absent very special conditions, a court cannot impose a penalty, civil or criminal, against an individual who has not received notice of a lawsuit being brought against them, or who has not received a fair opportunity to present evidence for themselves. The standardization for the means by which cases are brought, parties are informed, evidence is presented, and facts are determined is intended to maximize the fairness of any proceeding. Nevertheless, strict procedural rules have certain drawbacks. For example, they impose specific time limitations upon the parties that may either hasten or slow down the pace of proceedings. Furthermore, a party who is unfamiliar with procedural rules may run afoul of guidelines that have nothing to do with the merits of the case, and yet the failure to follow these guidelines may severely damage the party's chances. Procedural systems are constantly torn between arguments that judges should have greater discretion in order to avoid the rigidity of the rules, and arguments that judges should have less discretion in order to avoid an outcome based more on the personal preferences of the judge than on the law or the facts. Legal procedure, in a larger sense, is also designed to effect the best distribution of judicial resources. For example, in most courts of general jurisdiction in the United States, criminal cases are given priority over civil cases, because criminal defendants stand to lose their freedom, and should therefore be accorded the first opportunity to have their case heard. European history and concepts, procedural law, and substantive law in various languages. Procedural law, in contrast to substantive law, is a concept available in various legal systems and languages. Similar to the English expressions of the Spanish words derecho subjetivo and derecho material or derecho sustantivo, as well as the Portuguese terms for them, direito adjetivo and direito substantivo. Other ideas are behind the German expressions formels recht and materials recht, as well as the French droit formal droit matter copyright real, the Italian diritto formel diritto material and the Swedish formel ra currency tt material ra currency tt. All of which, taken literally, mean formal and material law. The same opposition can be found in the Russian legal vocabulary, with th 1/4 th degree n th micron n euro th degree th noeth 1/2 th 3/4 th micron th n euro th degree th squared th 3/4 for substantive law and th n euro th 3/4 n th micron n n n florin th degree th noeth 1/2 th 3/4 th micron th n euro th degree th squared th 3/4 for procedural. Similar to Russian, in Bulgarian th 1/4 th degree n th micron n euro th degree th 1/2 th 3/4 th n euro th degree th squared th 3/4 means substantive law and th n euro th 3/4 n th micron n n florin th degree th 1/2 th 3/4 th n euro th degree th squared th 3/4 is used for procedural. In Chinese, procedural law and substantive law are represented by these characters, ca cubed, and a registered trademark a 1/2 a cubed. In Germany, the expressions formels recht and materials recht were developed in the 19th century, because only during the time was the Roman actio split into procedural and substantive components. The substance of procedural law/substantive law in Europe. In the European legal systems, the Roman law had been of great influence. In ancient times, the Roman civil procedure applied to many countries. One of the main issues of the procedure has been the actio. In the procedure of the legis actions, the actio included both procedural and substantive elements. Because during this procedure the praetor had granted, or denied, litigation by granting or denying, respectively, an actio. By granting the actio, the praetor in the end has created claims. That is, a procedural act caused substantive claims to exist. Such priority is contrary to what we think of the relationship nowadays. But it has not only been an issue of priority and whether the one serves the other. Since the actio had been composed of elements of procedure and substance, it was difficult to separate both parts again. Even the scientific handling of law, which developed during medieval times in the new universities in Italy, did not come to a full and clear separation. In Germany, the unity of procedure and substance in the actio definitely was brought to an end with the codification of the Bar 1/4 Ehrlich's Gesetzbuch, which came into force on January 1, 1900. The expression Anspruch, meaning claim, has been cleared from procedural elements. And this was the time for founding the terms formelles/materials recht. However, after World War II, the expression formelles recht obviously was found to be contaminated, and to a broad extent has been replaced by proceedings recht, narrowing the idea behind it to law of litigation. See also, civil procedure, criminal procedure, hearing, legal technicality, Vyavahara, literature, Europe in ancient and medieval times/Germany, Andreas Kuhlmann, Begriffsunproblem-Geschichte des Verfahrenszieltnisses von Formellem und Materiellem Recht, edition, Dunker and Humblot, Berlin, Schriften zur Rechtsgeschichte No. 68, 1996, notes. Further reading, Cardozo, Benjamin. In the Nature of the Judicial Process. New Haven, Yale University Press. Frank, Jerome. Law and the Modern Mind. Birmingham, Alabama, Legal Classics Library. Levi, Edward H. An Introduction to Legal Reasoning. Chicago, University of Chicago Press. Marshall, Thurgood. Thurgood Marshall, His Speeches, Writings, Arguments, Opinions and Reminiscences. Chicago, Lawrence Hill Books. Miller, Arthur S. Politics, Democracy in the Supreme Court, Essays on the Future of Constitutional Theory. Westport, Connecticut, Greenwood Press. Tribe, Lawrence. God Save This Honorable Court, How the Choice of Supreme Court Justices Shapes Our History. New York, Random House. Slemier, William. The Legal System in Operation. St. Paul, Minnesota, West Publishing. External links, U.S. Federal Court Rules.